everybody. I'm Aishley Verma, a legal intern with LEXIS and Company. So today, in the video, I will be dealing about Section 10 of Indian Contract Act, which basically deals with the essentials of a valid contract. So most people assume that once one party has made an offer and the other party has accepted, a contract has been formed. However, there is more to a valid contract than this, and this has nothing to do with how formal the agreement is. A contract can be formed or can be formal or informal, written or even oral also. Section 10 of Indian Contract Act 1872 deals with the provisions for the valid contract that can be binding on both the parties. So a contract is valid and legal binding if and legally binding if the following 6 elements are fulfilled or are present in a contract. Number 1 is offer, number 2 is acceptance, number 3 is consideration, number 4 is intention to create legal relation, number 5 is legality and capacity, number 6 is free consent. First is offer. So the offer and acceptance analysis forms the basis of a contract and the formation of a valid contract. Developed in the 19th century, the offer and the acceptance formula identify the point of formation where the parties are of one mind. That is the parties are on same platform. An offer is a proposal constituting specific terms and conditions of one party to enter into any agreement with another party, which is essential to form a contract that is enforceable. So also there is a difference between offer and invitation. So it is very important to distinguish between the two. A valid contract requires an offer to be accepted, whereas an invitation to treat is not an essential element of the valid contract. Second comes the acceptance. So acceptance is an agreement to the specific terms of an offer. Acceptance basically means agreeing to the terms and conditions of other party to the contract. An offeree can accept an offer in any reasonable medium if the country or the state does not require any specific form. Also, there is a case in the case of Maharashtra Rajya Sahakari Kappas Utpadak Panan Mahasangha Limited versus Manga Bhaga Chaudhary, year 2009. It was held that by the Bombay High Court that if there is no acceptance of a proposal by the defendant, contract would not be concluded. Contract would not be considered as a concluded contract. Further comes the consideration. Consideration constitutes something for the benefit of the person who has the obligation or who makes a promise to do something, that is the promisor. So basically it creates a security for the promisor. According to Section 23 of Indian Contract Act, the object or the consideration of a contract has to be lawful, which means unless it is not forbidden by law, is of the nature that is if permitted it would defeat the provision of any law. If it is fraudulent or involves injury to the person or property of another, or the court regards it as immoral and opposed to the public policy. So if these conditions are not fulfilled, then the object or the consideration will be termed as unlawful. Next comes the intention to create a legal relation. To bind both the parties to the contract should have a specific intention that can create a legal relation resulting in an agreement. So this can be well understood as that through this agreement the parties hold liability to each other. Agreements in a social or household or of household nature are not contract because parties do not intend to build a legal relationship in it. Next comes the legality and capacity and certainty of the contract. So in any agreement, if there is any uncertainty and both the parties are not capable of finding the right path, then it is deemed to be void. As a part of the essential of a valid contract, the terms and conditions of the contract should be concrete. Any contract which is uncertain in any sense can be termed as void. The terms mentioned in the agreement should be capable of performing specific thoughts and should also perform the legal and capable contract. Next comes the free consent. So according to section 13 of Indian Contract Act 1872, the consent of any contract should be free and both the parties are said to consent when when they agree upon same thing in same sense. So according to section 14 of the same act, Indian Contract Act, the consent obtained should be free from coercion, undue influence, fraud, misrepresentation, mistake of subject of the contract. So these all elements should be there in a valid contract, and then the contract is enforceable. That is it. Thank you.